Hello everyone, welcome to my channel Telecast. I'm Mira Kangala. You're watching the court verdict from the lawyers speaking about the ADC, the ruling of the Supreme Court, and the various judgments that were passed. Endeavor to watch to the end. Drop your comments, drop your opinions. Don't miss trending videos. Endeavor to watch this video to the end.
The appeal of ladies Senator David Mark.
Relax.
In fact, the order made by the Court of Appeal that status quo ante bellum be restored had been set aside. In other words, the basis upon which INEC acted to remove the name of Senator Mark and his escort had been removed by the Supreme Court, agreed that the order of status quo ante bellum made by the Court of Appeal was unwarranted, had no basis to make it. It was unnecessary, but affirmed that we should go to raise the question of jurisdiction before the trial court. In other words, the Supreme Court allowed the appeal. The objection to the competence of the appeal was dismissed. The appeal was valid, but they agreed that we ought not to have come to the Court of Appeal for the question to come and show cause. And so we're going back to the Court of Appeal.
How do you react to that? What you hear your pronouncement? How do you feel?
In my view, that's it. The Supreme Court is a court of policy, and like you hear their lordship say, they are all Nigerians. They are aware of what is going on. Democracy must flourish, and it must thrive.
So finally, what's the state of the matter at the Federal High Court? Where are we at the Federal High Court?
When we get there, I'll answer you.
Very well. Thank you very much.
ADC! Arise! Are we going? Let her show. Hold on. It's okay.
And then react to the judgment just delivered.
Well, I mean, it's a victory for multi-party democracy in Nigeria. We have repeatedly maintained that anything contrary to what the Supreme Court had ruled would have set Nigeria's democracy back by many years. So we are glad, we have remained confident in the judiciary. We have repeatedly maintained that we are confident in the judiciary, and we are very proud as Nigerian citizens today that the Supreme Court has not let the judiciary down, has not let Nigeria down, and as Nigerians we are very proud. And this means to us that democracy will survive in Nigeria. Then we can go back and begin to do the hard work.
And the implication of the judgment. What is the implication of the judgment?
As we have had the lawyers explain, the full implication is that the basis of the INEC acted by removing the name of David Mark, Nafiu Bala Gombe, and other executives from its portal have now been removed.
That's it.
So INEC now has an obligation to immediately restore the name of David Mark, Nafiu Bala Gombe, and other ESCO of the party on its portal, and begin to continue to deal with us until the High Court determines the case.
Thank you very much. Can we have your full name on camera?
My name is Bolaji.
Okay. This judgment is not just judgment, it's a justice. And I'm the lead counsel for Nafiu Bala Gombe, who is the plaintiff at the Federal High Court and the first respondent at the Supreme Court that just delivered judgment in respect of that appeal today.
So your reaction to this judgment just delivered now?
Okay, thank you very much for that very, very good question. Now, I need to highlight the fact that the appeal that gave rise to today's judgment was predicated on 7 grounds of appeal. 6 of those grounds failed. The Supreme Court dismissed them. Now, the only ground that succeeded is the ground that dealt with the issue of the consequential order to maintain status quo ante bellum. And the view of the Supreme Court was that the court that can make an order for status quo ante bellum is a court that has proceedings pending before it. And since the Court of Appeal had correctly held that the appeal before it was an incompetent appeal, that was a complete abuse of process, there was nothing again pending before the Court of Appeal to which it can engraft an order of status quo ante bellum. That the court that still has proceedings pending before it was the Federal High Court. That is the only court that can make an order for status quo ante bellum, and not the Court of Appeal, because the Court of Appeal correctly held that the appeal filed by Senator David Mark was an incompetent appeal. It was incompetent because it was an appeal against the exercise of judicial discretion by the Federal High Court, and that the Federal High Court correctly exercised its discretion by saying, you, defendants, come and show cause why I should not make this order. Come and show cause why I should not make this order. More importantly is that appealing against such an order, you cannot now properly engraft an issue of jurisdiction on it. This was the main decision of the Supreme Court. So the appeal in the main failed. It failed because the real objective of this appeal was to get the Supreme Court to decide the issue of whether or not the claim before the Federal High Court was justiciable. Was it a justiciable claim or was it not? The Supreme Court said the Court of Appeal properly declined to hear it because that issue is properly before the Federal High Court. We are going back to the Federal High Court for the case to be heard on the merits, on the basis of the order of the Court of Appeal for accelerated hearing. Let me make the point. The order for accelerated hearing made by the Court of Appeal was not a subject matter of appeal. So nobody challenged that order. So that order is still subsisting. So there's an order for accelerated hearing. So the Federal High Court, go ahead this case and hear it expeditiously and decide it.
So, sir, just lastly, in clear terms here, what do you understand by when the court said that the judgment succeeded in part?
Now, I have now explained to you that the judgment succeeded in part only in respect of ground 7. Out of 7 grounds of appeal, 6 failed. They filed 7 grounds of appeal. Grounds 1 to 6 were a complete failure. Supreme Court dismissed them. The ground 7 that succeeded is limited to the narrow issue of the consequential order. Status quo ante bellum. Should the Court of Appeal have made that order? Supreme Court said no. That the only court that can make such an order is the court that still has case pending before it, which is the Federal High Court. So that is the only narrow issue on which this case succeeded. It failed on every other ground.
Thank you very much, sir.
That is now for the courts to decide. Are you with me? That is for the court to decide. That issue. That issue, that question, the question you just asked, did not arise for decision at all by the Supreme Court. The Supreme Court did not enter into such an issue to decide it. Whether this person is the chairman, whether this person, that issue didn't come up at all. It fell within a very narrow technical compass. Was the Court of Appeal right to decline to hear their appeal? That's all. And Supreme Court said, yes, they were right, but they were wrong to have made that order for status quo. INEC did not remove anybody.
They recognized him.
INEC simply acted on the order of the Court of Appeal.
Okay,
That's
so
what
in
all
clear
this.
terms, what we're trying to understand is now that that order of the ante has been vacated, does that now mean that you'll be reinstated?
You see, let me emphasize, because what we are dealing with now is a principle of law. The most fundamental principle of law is that whenever, and I repeat the word, whenever a case is seeking for an injunction, that do not do this, do not do that. Whether an order is made or not, you act at your own peril if you go ahead to do what is being sought to be restrained. Because if the case succeeds, you are going to do everything you have done will be reversed. That's the effect of it. You act at your peril. This is the decision of the Supreme Court itself. Ojukwu and Lagos State government. It's an old case, 1986. So this is a firmly established rule of law. Whether an order is made or not, the moment we are aware of an injunction, you have to just simply stop doing what you are doing and respect the authority of the courts to decide the case one way or the other.
Please let's have your full name, sir.
The name is Robert Emunkweru, SA.
Thank you so much.
Thank you.